I think we've noted on this table, Martin has also alluded to that. The Supreme Court is clear that the minute, there are two instances. One, if the president failed to, establish a prima facie case, in that instance, the in-camera-ness of the proceeding comes to an end. Also, when the committee concludes its work and submits its report, when that is done, the in-camera-ness also comes to an end. So I think it is a belated argument to say that the action before the High Court would in any way amount to a needless incursion into the in-camera-ness of the whole proceeding. In fact, the minute the Formal Committee submitted its report to the President, the basis of which the President acted, that in-camera-ness, the myth is broken. Now, and as Martin said, Ghanaians now have the right to know whatever happened, particularly the entire report. All right, the question we must ask ourselves is the Chief Justice, the removed Chief Justice, appealing the recommendation of the Article 146 Committee? I don't see that. In fact, I'm inclined to agree with ABG when he said the judicial application, the judicial review application has a semblance of an appeal. In fact, I read the entire document and I looked at the relief. In fact, she's coming under a judicial review application. When I look at the reliefs are straightly judicial review reliefs. But I had issues with the grounds. In fact, the grounds, the way the grounds were couched amount to a tacit invitation to the High Court to, in fact, go through or to intervene by reviewing the substantive work of the committee.
That's why it's an appeal.
but you see, that is an issue with her lawyers. Because if you are coming for judicial review reliefs and you have grounds, some of which do not support the reliefs, I think that is their issue. But I've heard many argue that let me acknowledge, the Article 146 is genuine. In fact, it is unique, as EDUG hinted at. And but the argument that you cannot question the recommendation of the committee is disingenuous.
Why?
And this is my point. After the provisions of the 1992 Constitution, right? The provision must be read as a unified whole. In fact, they do not operate in isolation.
Right.
And the thing is that the Constitution is anchored on key principles, including justice, fairness, probity, and accountability. Therefore, any interpretation whatsoever that ignores these principles is dangerous and must be opposed by any well-meaning Ghanaian. Why am I saying this? Every Ghanaian, the minute the committee is done, you can question the manner the work was done. You can question it. And it must not have, the framers of the Constitution should not have stated it in Article 146 because the whole Constitution is a unified whole. So when you are reading, you must make sure that whatever committee is entrusted with work to do, like the Article 146, that work must meet the test of justice, fairness, probity, and accountability. On that basis, the removed Chief Justice has legitimate grounds to bring a judicial review application to interrogate. But we all know, the lawyers on this table know that judicial review application is circumscribed. When you are going for judicial review, you must not couch your grounds in the manner that look like an appeal. Particularly, and as EDUG said, appeal is a creature of statute. And per Article 146, there's no room for appeal. As for that, it's not open for debate. Nobody should argue about this. You can't appeal the recommendation of the committee. However, you can question if you have legitimate grounds, particularly when you feel that the procedure the committee adopted were not, were not in your favor or do not meet the test of the Constitution. You can question them. And she cited Articles 23 and 296. And I was hoping that maybe her grounds will be well couched to justify those provisions. And I have said, Alfred, these are matters that should be that should be done, worked on by her lawyers, her counsels. I'm not in the position to advise the council.
Okay.
But I think she has every legitimate ground to question the work of the committee. And any argument and any submission that there's no room for anybody to question it because the committee has done its work and the president has acted on it, by reason of that, nothing should be done. I think it's disingenuous. Albert, I think if any young lady is listening to us, the work of the Chief Justice will not benefit her today, but it will benefit her tomorrow. Any young lawyer or woman listening to us.
Why do you go on that path?
No, do you know why?
What about the old ones?
Alfred, now the question is, Alfred, this is a question. People have addressed her as a perennial litigant. Alfred, the question is, must she put the brake on her litigation? I don't think so. The question I always ask is, has injustice in the system stopped? You remember the late Dr. Martin Luther King Jr. in his famous letter from the Birmingham jail, which he wrote on the 16th of April 1963. He said, any injustice anywhere is a threat to justice.
I think you are confusing politics and law. You see, you can have an advocacy based on policy, reform. That's permissible. To advocate that, for instance, maybe in the superior wisdom of the framers of the 1992 Constitution, and thankfully you have H. Kwesi Prempeh's committee still working. Maybe an additional clause should be provided in Article 146 to allow for persons dissatisfied with the work of the committee to possibly vindicate that right. That is politics.
That's appeal.
That is policy. But I'm saying that the Constitution structured now does not permit. And I'm saying that, yes, it's true. Everything conceivably can be litigated in our court. And that is when the Ghana Bar Association in 1994 decided that they would tweak the qualification to become a judge and to have the Supreme Court to pronounce on the fact that Aban was not fit. The court said, look, immediately we say Aban is not fit. What we have done is to conclude on an Article 146 proceedings. And so it's a clever way of getting us to do an Article 146 work using litigation or a writ and decline jurisdiction. The point I'm making is that, you see, in this particular instance, where the invitation, and look at, you yourself have problem with even the grounds. The two grounds.
That's an issue.
Because you see, judicial review, when you do judicial review, the principle of law is that you are not substituting your decision for the decision maker.
Of course, it's clear.
If you look at the Westbury formulation, 3 essential grounds: illegality, procedural impropriety, the issues of legitimate expectation and whether or not, or a breach of the rules of natural justice. So if you look at the Westbury formulation and you apply, it is either you are saying that there is a rule of law that the committee did not apply. 2, that you have a legitimate expectation and that was not, respected, or that there was procedural impropriety or there was a breach of the rules of natural justice. It is not for a high court to substitute. So immediately you bring the question of fairness. And that's what the committee did not meet that legal requirement. That becomes a problem. The court does not have the power to engage
in the jurisdiction of the High Court in this matter.
Completely. Foreclosed.
Key one, is it the thing is, quick one. The backdoor procedure that was flagged in the Aban case, as Eduji referred to, I don't think it's playing out in this matter.
Why is that?
I have said that when you look at the reliefs were couched in a tacit judicial review application reliefs. But I have faulted some of the grounds. And I think these are matters the lawyers should work on. But the thing is that, Alfred, on this table, what I am finding it difficult to accept is a submission by Eduji and some other people in the media that there's no way around the Article 146 to question, in fact, the procedure the committee adopted in arriving at its recommendation, arriving at
show us the way, Brako Powers.
I have said that the Constitution, when you are reading, you are just picking Article 146 and isolating it. And I'm saying that the Constitution as a political document, you should read it as a unified whole, thereby ensuring that no one provision operates uniquely or in isolation. You must get them in tandem. And I have noted that the Constitution is anchored on key principles. And those principles, if those principles are missing in any decision that is arrived at by any committee established, properly so-called established by the Constitution or an act of Parliament, any aggrieved individual can question the procedure. However, I have also noted, Alfred, and if you realize that appeal must clearly or should clearly have been given to you, the right to appeal should clearly have been given to you by the law. And I have said that Article 146 has no room for appeal. Be that as it may, you can question the procedure if only you have legitimate grounds. And I think the argument should not be pushed around or be peddled in the media that there's no way around it. That is, I see that as selective and cagey and narrow interpretation of the Constitution. And we must not, saddle ourselves with that. We must open up. I think
to be clear, did you say we can't question at all, or is the High Court? Because for the Supreme Court, you question. The decisions show how we are questioning the processes.
And that's what I said, that you see, in terms of questioning, it's the High Court. It's foreclosed.
What is foreclosed?
So it can be done in the Supreme Court. I'm not hearing him saying that you can't question at all, but it's the venue.
The venue. No, the thing is that
let's not run amok. We have a specific matter before us, a judicial review. The High Court jurisdiction has been invoked, and I submit that the High Court jurisdiction is completely ousted.
So when they go, maybe they can.
Please, that is not a matter. It's not a matter for now.
Okay. Yes. I don't subscribe to that argument.
Okay.
I think legitimately the High Court has jurisdiction to hear a judicial review application.
Okay.
Particularly because we know that when it comes to matters...
That's not what we are fighting. We're saying this Article 146 matters she's raising. Are they for the High Court judge or for the Supreme Court? Nobody is saying...
No, I think for me, I think she's in the appropriate forum.
Okay, right.
She's in the appropriate forum. It is open. I understand, individuals like Eduji and Co in the media who have a different position. But the thing is that usually your argument is based on where you stand. And where you stand will also inform what you communicate. But so I read largely she is properly before the court. I have issues with some of the grounds. It is something the lawyers will have to work on.
Okay.
But I think she has every legitimate ground to question the procedure adopted, but not the conclusion of the committee.